Renters' Rights Act 2026 and what this means for landlords. The UK rental market is on the brink of its biggest shake-up in decades. From the 1st of May 2026, the Renters' Rights Act will begin rolling out, introducing reforms that fundamentally change how landlords let, manage and regain possession of their properties. These changes aim to create a fairer, more transparent system for tenants, but they also bring new responsibilities and challenges for landlords. Key changes coming in 2026. Number one, the end of Section 21 no-fault evictions. The most significant reform is the abolition of Section 21 notices, which previously allowed landlords to evict tenants without giving a reason. From May 2026, landlords must rely on Section 8 grounds for all other statutory reasons, such as serious rent arrears, antisocial behaviour, or an intention to sell or move into that property. This shift means eviction will become more evidence-based and formal, requiring clear documentation and compliance with updated notice periods. Number two, move to periodic tenancies. Fixed-term tenancies will be phased out. All new agreements will default to assured periodic tenancies, allowing tenants to stay indefinitely and leave with 2 months' notice. Landlords can only end these tenancies using valid legal grounds. This change increases tenant security and reduces the churn, but also means landlords lose the certainty of fixed-term end dates. Number three, rent controls and fair practices. Rent increases limited to one per year with at least 2 months' notice. Ban on rental bidding wars and discrimination against tenants with, say, children or those receiving benefits. Restrictions on taking more than 1 month's rent in advance. These measures aim to curb exploitative practices and stabilise the rental market. Number four, new compliance requirements. Mandatory landlord registration on a national database. Phase 2 of this is coming later on in 2026. Joining a landlord redress scheme to resolve disputes without court action. Decent Homes Standard extended to private rentals, requiring landlords to prove properties are safe and well maintained. Failure to comply could result in fines of up to £40,000 for serious breaches. What does this all mean for landlords? The operational impact. Longer tenancies mean fewer automatic terminations, so landlords must plan for reduced flexibility. Higher documentation standards. Eviction claims will require robust evidence. Portfolio strategy changes. Lenders and investors may reassess risk due to uncertainty over tenancy duration. There's also financial considerations which need to be considered as well. Predictable rent reviews, these can help with budgeting, but limits on increases may affect the profitability. Compliance costs such as upgrading properties to meet the Decent Homes Standard, these could be significant. Reputational and also the legal risks. Non-compliance will attract tougher enforcement, including civil penalties and rent repayment orders. Councils will have expanded investigatory powers from late on in 2025, so landlords should act now to avoid last-minute issues. How to prepare now. Review tenancy agreements and update them for periodic terms. Audit property standards against the Decent Homes Standard. Improve record keeping for maintenance and communications. Engage with compliance partners and consider joining professional landlord associations to gain some guidance. The Renters' Rights Act 2026 represents a cultural shift in UK renting towards stability, fairness and accountability. For landlords, success will depend on early preparation, It'll also depend on professional management and a commitment to compliance. Those who adapt quickly will not only avoid penalties, but will also build stronger tenant relationships and long-term portfolio resilience.